This case isn't just about the right to bear arms. It's about who the law chooses to protect when the Second Amendment collides with public safety. It's about survivors of domestic violence, about restraining orders that mean something, and about whether the Constitution makes room for people at risk, not just people with rights. When gun rights are absolute, whose life becomes negotiable? Let's break it down. Meet Zaki Rahimi. In the year 2020, he assaulted his ex-girlfriend, fired a gun at a witness, and got hit with a domestic violence restraining order. That order barred him from owning firearms under federal law, but Rahimi did not stop. He violated the order, threatened another woman, and went on a 5-shooting spree in Texas. When police found guns in his home, he challenged the law, saying it violated his Second Amendment rights. The Fifth Circuit agreed, but in June 2024, the Supreme Court reversed in an 8-1 decision. The court said, if a judge finds you pose a credible threat, the government can temporarily disarm you. So, this case is not just about guns, it is about who gets to be protected when the law meets the Second Amendment. So, what is the impact? Legally, the court clarified that modern gun laws do not need to be historical twins, just historically consistent. That is a big shift from the rigid history-only test in the Bruen case. So what was the history-only test from Bruen? In the 2022 New York State Rifle and Pistol Association v. Bruen decision, the Supreme Court established a new standard for evaluating gun laws. The rule was this: a gun regulation is constitutional only if it's consistent with the nation's historical tradition of firearm regulation. That meant modern gun control laws had to be backed up by direct historical analogues, usually from the 1700s or early 1800s. If there wasn't a similar law back then, the modern version might be struck down. This rigid approach made it extremely hard to justify any contemporary gun laws, especially those designed to respond to modern threats like domestic violence or mass shootings. So, that is why it is a big shift from the rigid history-only test. In United States v. Rahimi, the court pulled back from Bruen's ultra-rigid history-only stance. How? The court still referenced tradition, but said modern laws don't need to be exact replicas of 18th century statutes. They only need to be relevantly similar to historical practices, especially in purpose and principle. In plain terms, they said the government can restrict guns from people deemed dangerous, like Rahimi, who had a restraining order and committed multiple shootings, even if 1791 didn't have a law written exactly that way. Economically, gun violence tied to domestic abuse costs the United States billions in healthcare, policing, and lost productivity. Socially, this is a win for survivors of domestic violence, especially women, who are 5 times more likely to be killed when a gun is present. But here is the twist. This ruling is narrow. It does not answer whether non-violent felons, drug users, or mental health patients can be disarmed. That fight is still coming. So next time someone says the Second Amendment is absolute, ask, even when it puts someone else's life at risk.
Smash that like button, subscribe and follow us on Instagram and YouTube at 99rights_online for more legal quickies. Catch you later. And remember, knowledge is power. Stay informed, stay empowered, and keep fighting for what's right. See you next time. Liked this? If you found this information helpful and inspiring, don't keep it to yourself. Share it with your friends and family.